Hi everyone, I'm Consumer Investigator Dale Cardwell, and this is another opportunity to ask Dale. Today we're going to talk about probably the number one question we get here at the TrustDALE offices is what rights do homeowners have when they feel abandoned by their contractor? What constitutes their right to walk away or to no longer be liable for payment? Joining us is attorney and contracts expert Kevin Veler. Kevin, welcome.
Thank you.
I know you get this question a lot.
I do.
So let's start at the beginning. What constitutes job abandonment for home services here in Georgia?
I wish there were a clear answer that I can just say, this is when a job is abandoned. But unfortunately, Georgia law doesn't really cover or doesn't really specify when abandonment. The closest I could come from looking is when we look at the Contractor Licensing Act that was passed in 2007 or so. It talks about being the state licensing board for state licensed residential and general contractors. They can take away their take away their license if they abandon a job that they're liable for under contract.
What is abandonment?
Well, in their case, they're saying it is presumed abandoned after 90 days.
Okay.
Now, I would probably suggest for most consumers, 90 days is a long time to wait. And that's 90 days with no action or anything else and that kind of thing. It's going to depend on the project. If the project is somebody replacing your roof, 90 days is way too long to wait.
Yeah.
If it's sitting there with you at your kitchen the whole time, that's a hard time to wait too. But I would generally say the first thing you want to do is look at your contract. What does it require under the contract for notice and opportunity to cure?
So it seems to me it'd be really smart to put time deadlines in a contract, but don't most contractors resist those?
The contractors resist having a specific start date and a specific end date. However, it's not bad to say once you start the work will progress and finish within so many days. Most of them are going to say window replacement. It's generally going to take a day or two for most residential projects. Kitchens are going to be longer. Carpet replacement, that could be generally done in a day or two. So it really depends on the on the amount of work and the scale of work.
So let's say someone does extend past 90 days. What action do you have available to you? Do you have small claims court? Can you simply refuse to pay, hire another contractor? What are my options as a homeowner?
Well, first thing is, again, look at your written contract. Hopefully you have a written contract. That's the first thing that's always recommended, is definitely have a written contract. You want to look at what the time periods are in that contract. Does it have a provision about abandonment, or is it just generally notice and default? And how long is the cure period? Does it have a default? So generally I want to say you want to give that notice, and then you want to give time to cure, whatever that requirement is, in a document they haven't done the work.
Is it possible to put penalties into a contract?
It is very possible, and in commercial contract, that's very common. In residential contract, it's not a common thing, and it depends upon the contractor and how good you are at negotiating your contract.
Most contractors are familiar enough with the law to know that it helps if they simply show up, but is that a problem where they show up, have a conversation with the homeowner, but simply do no work?
That is a problem, and you want to document that. A good homeowner is going to be documenting, if you're doing your job right, you're going to be documenting what days that they show up, have it written down, make a contemporaneous record of who showed up, what crews are showed up. You have a camera these days that it's not like the old days where you had to go out and get film and take it out and get developed. Take pictures, take videos. I even tell people they're in the state of Georgia, as long as they're calling within the state, you have to look at every state, but we're a one-party state as the phone calls. You can record a phone call without disclosing it to the other side. I mean, you may not want to tell them you're recording it. You don't have to tell them in Georgia law as long as you're the party talking.
It's called one-party consent.
That's right, and that's a good way to get a record of when it is you says, I'm coming in.
So what does Georgia law say about a contractor's right to repair work when both parties agree that it needs to be repaired? How long do they have to do it before you can hire another contractor?
In Georgia, we have what is called the Right to Repair Act. And so that means if you're following that act, Then you have to give notice to the contractor of what the deficiencies are. You have to provide him any expert report you have and other things. And there's a process for doing that. It's a 30-day notice, and then they have 15 days to inspect, and you go through all of that. That's actually explained somewhat on the Secretary of State's website if people want to look there. If it's just a fact that they've installed something incorrectly, again, it'd be notice and opportunity to cure is whatever specified in the contract, and oftentimes that's 10 to 15 days, again, cured. Now, let me add one other thing, is some items, especially we saw during COVID, take longer because of supply chains. I, for instance, have my own bathroom right now has a leak. It is warranted by a very reputable manufacturer of shower equipment. It's been 6 months and it's still dripping. And I've got buckets collecting water because of the backlog, and I'm trying to make a warranty claim. So it's very frustrating sometimes. But I also don't want to rip out the walls and have somebody come in and replace it.
So let's get really practical. I've seen situations where a homeowner spends 70, 80% of the money committed toward the contractor. Something's not fixed. They're so frustrated, they just want to hire somebody else to get it done. Very often I've seen that the original contractor doesn't come after the homeowner for the other 20%. They're willing to let that go, but the homeowner is going to incur more expense. Is that fairly common?
Fairly common. It really depends on, I often say a completion contractor, first off, you're taking a big risk as a completion contractor to come in, because if you don't get the repair right, then you're going to be blamed, and it could be something else that's wrong that the original contractor did. So a completion contractor generally is always going to be more concerned about that. It's a question of, are they doing the right repair? If it's something that's behind the walls, like plumbing or other things, they don't know until they open up the wall. And once you open up the wall, then you've got to repair the wall. And how far back do you go, and tile and everything else. Another thing, before I forget, also let me mention, manufacturer's instructions are very important to look at. When you're looking at having claims about improper installation, and what is needed for repair, look to the original instructions. What was supposed to be done to set that, to install that product?
How long can I wait, or should I wait before I hire that completion contractor?
Again, notice an opportunity to cure. Once you get past that cure period and you've given proper notice, then basically after that 10 or 15 day, whatever that cure period is, a reasonable time, if there's nothing specified, then you can hire and bring in somebody. But then you've got to worry about, are you documenting? If you're going to go after the person, after the original contractor, let's say you don't have any, you spent your money, or it's going to cost you have 20% saved back, but it costs you actually 25% of what is, and you want to go after the original contractor for that money. Then you're going to have to figure out, can I make that claim, and what do I have to do to document that evidence?
And as an expert in that space, you're going to tell people it's often not worth your money to go after that contractor.
To hire an attorney is very expensive, and it's probably not worthwhile for a couple $1,000s. Now, let me also remind people that in Georgia, small claims court, which we call in Georgia magistrates court, has a limit of $15,000. So if it's under $15,000, you can represent yourself. And generally the owner of a company on the other side can represent themselves, as long as they're the owner. There's some rules about whether or not they can do that.
But I've got to warn folks that sometimes you're taking your chances on the expertise that's on the bench. Sometimes they don't understand the problem at all. They don't understand the law. You don't even have to be an attorney to be a magistrate court judge in some cases. Let me finish up by asking this. Should I be afraid of a lien if I'm a homeowner?
A lien itself is no. I would not be afraid of. A lien means a preliminary filing to say I'm going to file a lawsuit. It has to be filed within 90 days of the last day of work under Georgia law. All right. If there is a lien, that doesn't mean there's a lawsuit. Now, once they file that lien, they don't have an immediate right to take your home. It doesn't, and I often tell people, unless you're selling your home or unless you're doing some refinancing, generally you don't want to panic about it. The contractor is counting on you, especially the ones that are problematic. They know the lien law. They know how to scare people. And so they will file a lien, but they have really no intent on going through with that. you can, and I just did this for a client, you can file a notice of contest, which is there's a statutory form. It's in Georgia code. You can look at the form, fill it out, file that with the county, and that shortens the time period. The time period to bring a lawsuit for a lien action is 360 days. It will shorten that time period to 60 days from the notice of contest. And if they don't file that action within 60 days, and then file the proper notice within 30 days after that, so after 90 days, the lien can be ignored.
Otherwise known as, I can call your bluff.
That's right.
Kevin, how do people find you? How do they get in touch with you?
For me, it's the KMV at kmv@kmvlaw.com.
Excellent.
My website.
Thank you for volunteering your time today to help people, because a lot of folks will watch this, and it's such an important thing. I'm so happy that you joined us.
Well, thank you.
And we'll see you next time on Ask Dale.